Order. And we're going to take the roll call in just a second, but before we do that, I'm just going to introduce for the public that's here or watching at home, everyone up here on the dais. And so I'm Glenn Clark, the chairman, and my colleagues to my left, your right, is Mr. Lambert, and this is Vice Chairman Eisenbacher. This is Ms. Kupa. To my right is Mr. Desmond. This is Mr. Kalsunas, who actually is a alternate to this board, but for the purpose of this meeting tonight, he will serve as a full voting member of this board tonight. And then on the end here is Mr. Agawas. And then on the side over here is Mr. Evans, who is an administrative employee of the city, and he represents the city administration and serves as our liaison tonight. And then on the end is Mr. Modsney, who is an assistant city attorney, and he will, for the city of Troy, and he will serve as our legal advisor for tonight's proceedings. So at this time, Mr. Evans, if you can please call the roll.
Mr. Clark.
Here.
Mr. Agawas.
Here.
Mr. Desmond.
Here.
Mr. Eisenbacher.
Here.
Mr. Kaltsunas.
Here.
Mr. Lambert.
Here.
Ms. Kupa.
Here.
So we do have a full voting board here tonight, and we can proceed with our agenda. The next thing we're going to do now for the public's review is to call on Vice Chairman Eisenbacher to read our rules and procedures. So these are the rules that govern our proceedings here tonight.
The Zoning Board of Appeals is a group of 7 of your neighbors appointed by City Council to decide on requests for variances and other matters that are brought before them. A variance is a relaxation of the literal provisions of the zoning ordinance. Petitioners must indicate a hardship or practical difficulty with the land that would warrant the granting of the variance. Procedure. The board will hear the items in the order they appear on the agenda. When an item is called, the chairman will verify that the petitioner is present. Then the city administration will summarize the facts of the case. The petitioner will then be given an opportunity to address the board to explain the justification for the action requested. After the petitioner makes their presentation and answers any questions that the board may have, the chairman will open the public hearing. Any person wishing to speak on the request should raise their hand, and when recognized by the chairman, come up to the podium. The speaker should identify themselves with name and address, indicate their relationship to the property in question, for example, next door neighbor, live behind the property, etc., and state whether they are in favor of or against the variance request and give reasons for their opinion. Comments must be directed through the chairman. Comments should be kept as brief as possible and closely pertain to the matter under consideration. Only one person will be recognized by the chairman to speak at one time. At the conclusion of public comments, the chairman will close the public hearing. Once the public hearing is closed, no other public comment will be taken unless in response to a specific question by a member of the board. The board will then make a motion to approve, deny, or postpone the request. In order for the request to pass, a minimum of 4 votes are needed. If the request is not granted, the applicant has the right to appeal the board's decision to Oakland County Circuit Court.
Thank you, Vice Chairman Eisenbacher. Now we move on to item number 3, which is the approval of the minutes for the April 18th meeting of 2017. Are there any questions, comments, or concerns by a member of the board? Mr. Lambert.
Mr. Chairman, I would move we approve the minutes from the meeting.
So motion for approval. Is there a second?
Second.
Mr. Desmond seconds that motion. Any discussion on the motion that's before us? Seeing that there isn't, Mr. Evans, I believe we're prepared for a vote.
Mr. Agawas.
Yes.
Mr. Desmond.
Yes.
Mr. Eisenbacher.
Yes.
Mr. Kaltsunas.
Yes.
Mr. Lambert.
Yes.
Ms. Kupa.
Yes.
Mr. Clark.
Yes. Motion passes. Now we move on to item number 4, which is the approval of the agenda. This is to our board members. Are there any questions or concerns here? If not, we will consider the agenda that was presented to us as approved for this evening's proceedings. Item number 5, we'll move right into our hearing of cases. Is related to a variance request related to the property 3755 Euclid. Mr. Evans, could you please share with us this information?
Thank you, Mr. Chair. I've got a presentation at the front of the room. This is a variance request for property at 3755 Euclid. This is an aerial of the neighborhood. The subject property is circled and outlined in red. Now, this area of Troy is south of Waddles and west of DeQuinder. This is a close-up of the property, which is at 3755 Euclid. All the property in this view is zoned single-family residential, and with the exception of the church property immediately to the north, all the properties are used for single-family residential. Now, the subject matter involves adding an additional living space to the back of the house. The applicants provided several items in their application package, and we pulled some select ones for this presentation. This is what the back of the house looks like right now, and what they want to do is add on this single-story structure to the back. Now, they provided us, the board, I should say, several renderings of how this is going to look. Also some architectural details showing finishes and what that'll look like. Now, this is their site plan, and in this drawing, Euclid's at the bottom. And the hashed area is the subject portion of the variance request, the covered addition. The variance request doesn't include the decks that you saw there because they're allowed to be there because they're uncovered. The zoning ordinance requires that any additions with roofs to the house need to be set back 40 feet from the back property line, which is at the top of this drawing. And the applicant is proposing a setback of just over the 32 feet. So in order to proceed and construct as he would like to, he needs a variance from this board. I'll turn it back over to the board for any questions.
Thank you, Mr. Evans. Are there any questions for city staff?
Mr.
Gauss.
Mr. Evans, I have a question for you. I understand that there are other homes in that neighborhood that had additions built on the back. Were there other variance requests to the board in the past for those additions, or did the builder just go ahead and do it?
I didn't check specifically for variances, but this question did come up with either during the application process, and I pulled some setback measurements off the GIS, and it did appear that the houses that are in the area that are similar distance are actually the same, the requisite distance of 40 feet. At least that's what the GIS shows, yeah.
But what's the overall length of the extension? How far out is it actually coming? Do you have that information?
Now let's take a look here. That should be shown in the site plan. I'll bring it up here. Let me see if I can enlarge this here. "25 feet.
Thank you.
Anyone else? Okay, we will call the petitioner forward. If you are here related to this case, please come to the podium and identify yourself and state your relationship with the property in question.
Sure. Thanks so much. My name is Ash Cooperkar. I'm the owner, along with my wife, of the property.
Welcome. Would you like to share with us
Sure.
anything related to your request that you think that we should
Sure.
really study?
Yeah. So we're trying to stay in this house and stay in Troy itself and not have to go to any other city. We love Troy. We've been here for 17 years. We would like to have this as a great room and convert a master bedroom so this can become a retirement home. If we have the dimensions of 33 by 17, which would conform to the variance without needing a variance, then that would be exceptionally narrow and it would not look proper inside as well as outside. Hence, if we get the 25 feet by 33 and we go out 7 feet as the variance, then that will be the appropriate structure, both in terms of richness, appropriateness, our usability, and that exceptional shallowness will not be there. So I think it meets our needs, as well as it won't be exceptionally narrow, is the main point I want to draw.
Okay, anyone for this petitioner? Questions? Thank you very much. You can have a seat. So we're going to open the public hearing now at this point. If you're here to address the board on this matter, please proceed to the podium and identify yourself, please. Seeing that there isn't anyone coming forward, we'll close that public hearing, and I'm going to call on Vice Chairman Eisenbacher to read any communications on this matter to the board.
There were no communications placed on the table, and I saw none in the packet.
Thank you. So at this point in time, I'll bring it back to the board for any possible action, further questions, or inquiries of city staff.
I guess
Gauss?
I have one more question. Do we know anything about the property right behind the house? It looks like it's just woods, or how it's zoned?
I can tell you that it is zoned single-family residential. It's used as single-family residential. And see if I can zoom in on this aerial here to give you, everyone here, a concept of what. There we go. Yeah, so it's a single-family home, we know that.
And they received postcard communication from the city,
Right.
correct?
Yes, they
Yes,
did.
okay. Anyone else? I see the petitioner would like to speak again. Normally, once you've presented, unless it's like earth-shattering or, okay. Yeah. Thank you. Any members of the board, any member of the board would like to be recognized? Mr. Lambert.
Mr. Chairman, I would move approval of the variance by looking at the statement of practical difficulty. I believe it meets 3 of the criteria. Item B, the characteristics which make compliance must be related to the premises for which the variance is sought and not some other location. Item D, characteristics which make compliance must not have been created by the current or previous owner. And E, the variance will not be harmful or alter the essential character of the area in which the property is located, and that's clearly seen by the lack of public opposition to the proposed variance.
I second.
Moved by Lambert and Desmond. Is there any discussion by a member of the board on the matter in front of us? Mr. Evans, I believe we're prepared for a vote.
Mr. Desmond.
Yes.
Mr. Eisenbacher.
Yes.
Mr. Kaltsunis.
Yes.
Mr. Lambert.
Yes.
Ms. Koopa.
Yes.
Mr. Clark.
Yes.
Mr. Agawas.
Yes.
Motion passes. You have your variance. Have a very good night. So now we move on to item B, which is related to 71 Birchwood. Mr. Evans, can you please share with us the information on this case?
Thank you, Mr. Chair. This property is in order for a lot split to break one parcel into 2. Subject property is located in a neighborhood on the north side of Birchwood. This area is north of Maple Road and east of Livernois. Everything you see in yellow on this close-up is zoned single-family residential and used as single-family residential. And the items you see not in yellow, mostly along Livernois Road, are used and zoned non-single-family residential. And then that's what the neighborhood looks like with the zoning removed. This is the sketch plan provided by the applicant showing the outer boundaries of the property and then the split down the middle. I've added some color for visual. He's also shown the proposed location and footprint of a house and a garage. The zoning ordinance requires that any new parcels created in this district measure at minimum 7,500 square feet. If he receives a variance from you tonight, which he'll need, his proposed parcels are going to be 7,200 square feet. So he's 300 square feet short of what the ordinance requires in order to split. And he's provided the board some elevations of what his proposed houses will look like if he's successful here tonight. Now, turn it back over to the board for any questions.
Thank you, Mr. Evans. Ms. Cooper.
What school district does that property fall in?
I don't know. I might be able to check. Or maybe the applicant can also tell. I know he's
Yeah,
built
that's-
some
that's
houses in
Troy.
the area. Is it? Okay.
Yep. Anything over by Livernois? Any other questions? Could you just go back to the map? The street map, yes, and so, okay, thank you very much. Are there any other members of the board who want to, Mr. Lambert?
Yeah, Mr. Evans, the drawing Mr. Abathiri has given us shows that the setback between the dividing line between the two properties is about a 9-foot setback, whereas on the property line next to the homes on each side of it, it shows only a 6-foot setback. Is that correct?
Right, it has to be 15 combined total, and the least on one side can go as low as 5.
And then the second question is for Mr. Motzni. If, and I have no idea whether the board will approve this or not, but if the board were to approve the split, do we have the ability as a condition for that to require that the setback between the two proposed homes be reduced so that there's more setback on the sides along where the two houses on the adjacent to the property are?
This board, as with all variances, can impose reasonable conditions as long as they're related to the use of the land. As long as you could justify the condition as being reasonable and based on the use of the land, it would be a proper condition.
Okay, thank you.
Anyone else? Okay, so we are going to call the petitioner forward. He'll make his presentation to us.
Good evening. Name is Gary Abathura. I am the owner of 71 Birchwood here. I'm a Troy resident, 30 years. I know in some people that's not long enough for in the city of Troy. There's a lot of people longer, but I've been here for 30 years. I'm a builder in the city. I live in the city, develop. My kids go to schools in the city here. I purchased this piece of property to build 2 houses on, kind of not realizing it was only 120 foot deep when the next street over and the 2 streets over are all 130s, and I didn't look at it that close, and that's my fault. But as what I'm proposing to do is to build these 2 houses here. The front and rear setbacks will match, will meet the standards as the sides, total of 15. So the only way you'll know that the lots are small is if the houses would be smaller to fit on the lots. It's not not like I'm trying to put a house too close to a lot line and the rear, front, sides, or lefts. So last weekend, first thing I did is I went and started talking to the neighbors. Paul, could you go back to the neighborhood? First house I went to was 47 and talked to them. They're in favor of this. I went to 39 next door to it. They're in favor of it. Both have young families. They're happy to see more new houses come in the city with young families. 22 across the street was in favor of it. 40 across the street was in favor of it. And I talked to the lady at 68 was in favor. And I had my sons with me, and I thought, wow, this is going well. Then I went to 85, which is next door, because she's right next door to it, and she was not in favor of it and suggested I go to see the people at 88 across the street, and they weren't in favor of it, and suggested I go talk to the owners of 76 Vermont, and they weren't in favor of it. And I sat down and talked to them, explained to them what I was trying to do and what I have. The lady at 85 was afraid of a house being really tall next to her house. I can respect that. I know my plan shows 6 feet. I can adjust it over. I can keep my roof lines down lower on the houses. There's a few things I can do to be a good neighbor and try to build to make her happy. Today I stopped and talked to 95. She wasn't in favor of it, but she didn't say yes, she didn't say no, but she wasn't that inclined to it. So in looking at the map, I looked at the street of Birchwood. On the north side of Birchwood, where I'm at, existing right now is 5 houses. Across the street is 6 houses. And on Vermont, there's 7 houses in that same section, and on the other side, there's 7. So by me being able to split it and put 2 in there, it's not like I'm overcrowding the neighborhood. I would be falling right in the position of the other sections of the roads. If you go a little bit further north or south, all the lots are 130 foot deep, and they wouldn't need it for a variance for this. So I looked at it as I'm not putting more houses in there of what would really be in there. The lady at 76, her and her husband, just don't want more neighbors in the neighborhood, as they told me. Being that those apartments are going on Livernois, I think there's 31 units going in there. And I think that's just got everybody kind of seeing more neighbors in their neighborhood going in there. Like as I did, everybody on Birchwood I was able to talk to except the owners of 92. When I was there, I knocked on the door and they didn't answer. So, is there any questions I can answer for you?
Mr. Lambert?
Mr. Abathir, I'll give you the same question I gave the city staff. Would you be willing, as a condition for the split, to give a little bit more side yard setback to your neighbors on both sides of you?
Absolutely.
Okay.
The maximum I can go is 10 feet.
10 feet? Okay.
You have to have a total of 15, 5 being the minimum.
Okay.
So the only reason I go 6 is in case the basement is 3 inches off, that I'm not back for a 3-inch variance for being at 4'9" instead of 5. So I like to give a little bit of fluff room there.
Okay. Thank you.
Vice Chairman Eisenbacher?
Well, on the same point, clarifying, so it'd be 9 foot on the side or 10 foot on the side?
I could go 9'6",
9'6", okay.
and then 5'6" on the other side. So that, I just want those couple inches, because when the wall guy comes with his forms, yes.
And then the roof line that you mentioned, that's not dimensioned on that sketch on
I
the,
think that sketch right there might be like a 10-12. I mean, we can reduce it down to a 6-12 to lower the elevation
oh, the slope.
of the slope, yes. It'll
Slope
drop
6 and 12, so it reduced the peak?
at least 3 feet, yes. The architects like to draw things with really dramatic peaks to give it the effect, and we can drop and lower those grades there.
Okay. And that would be all the grades, so it?
Yes.
It looks?
Yeah,
nice
it all,
to the one.
yes, it's not just flat here and strong there. It'd be a 6 all the way around.
Okay.
To answer your question is, it's Troy High schools that are in the area right there.
Troy School District is, I mean, they can always rezone and it might end up in Athens, right?
There would be a big up in arms in the neighborhood, but yes, they could.
Anyone else for this petition, or? Okay, you can have a seat, please, thank you. So now we're going to open the public hearing, and if anyone would like to be heard on this matter, please come forward and identify yourself.
Hello,
Good evening.
my name's Denise Whitmer, and I'm at 76 Vermont. The property that I was talking about, we're just directly behind there, and I'm opposed to it. My husband, he'll speak, he's opposed to it. We knew that, when they sold the property there, that there would be one building, one house going in. But two is just like, we're so crowded as it is, with all these giant structures coming in. All the trees are being taken down. They're talking about the beauty and this and that. I think it's more of of course, it's a monetary thing. A builder buys property and that's what he wants to do, is make the most money off of it. But it really takes away from our neighborhood. It's just like everything that comes in there is just absolutely huge and not, it just doesn't fit with us. We're not comfortable with it. We're going to look out the back window and see two huge structures. Right now it's really nice. It's, beautiful, and I know that house is coming down, but everything else is coming down too. It's like the two houses, 39 and 47. They're like kitty corner. 47 is kitty corner to us, and that cuts off a lot of everything. There's just, fences now, and it's a very uncomfortable feeling to be encroached on like that. It's like, those are huge houses. I think I read 3,164 square feet apiece, right, for the houses. And that's just unbelievable. There's a lot, there's colonial after colonial being built in the neighborhood. There's two at 105, well, that 102 is, that's an old address, I think, 105 and 109. 109 has been built for quite some time now, and it's not filled up. 102 is a mess. It's just, the yard, there are people that live in there, and the yard is a mess, and it's just, I don't see where these huge structures bring in beauty to the neighborhood, especially for us. And we spoke to a lot of, we walked around all of Birchwood, almost all of Birchwood, 3/4 of Vermont. We went down Chopin, and aside from the 39, 47, and 22, nobody answered at those houses when we went by. It was a negative everywhere, you know, and I don't know, you know, a lot of people said they couldn't make it tonight, but they were going to send in emails or a letter or something, so I certainly hope that they did. I brought one with me, but we're just not, we don't want it.
Did you want to share that with the board?
This is just from the man that lives across the street.
Okay, well,
And,
we can add it to our communications. If you want to share it with Mr. Lambert at the end, we'll all take a look at it, and then it'll end up with the staff.
Not for it.
Thank you.
Thank you.
Thanks. Anyone else? Hello.
My name is Randy Whitmer. I live at 76 Vermont, too. And we've lived there since 1976, and I've lived in Troy 63 years, but at that address, 41 years. And if they put those houses in, it's going to block out the sun during certain parts of the season, and there's not going to be any privacy, and they're going to whack down the trees on each side to build these houses. There's nice trees on both sides of the old house that's there now. And it'll really change our way of life as far as going in our backyard goes. And all the neighbors I've talked to him, he's correct on most of them, but there's some that told me they did not want it. They're either going to send letters or emails. So if you cannot make a decision, I would like for you to approve for me to take up a petition, if possible. If you could delay this for a week or two, so I could take up a petition to get all these people that said they were against, but they didn't show up, obviously. So if you could delay it, I could take up a petition for another date, if possible. Because everyone we talked to said they were against it. And like I say, it's due south from us, so it's going to block off the sun, these tall houses that they're going to build in there. One would be fine, but two, no. It's just too much. And then we have the Amber Apartments on our west side, and that's going to block off our sun on the west side. But that's already a done deal. That's a 3-story deal. So these two in the back will add insult to injury as far as I'm concerned. So I would appreciate it if you can't make a decision to delay it, for me to take a petition up, and I can come back another day and show you guys.
Thank you for sharing your
Okay.
question. Yes,
Thank you.
Could you say again which house number you were?
76, directly behind.
Okay.
We're right
Same
behind.
house as the first speaker.
Yeah. So they're going to be monster houses, going to block off our sun from the south.
Do the houses at 47 and 30, they don't, it's at 47 and 39, Birchwood? Does the height of that house?
85 was against it, 47 didn't answer the door when I...
The question is the height of those houses affecting you?
47 is, yeah, 85, no, 47 is a newer house. But
Thank you.
Mr. Eisenbach, just from the public record, 47 is 2,800 square feet, and 39 is 2,700 square feet. So they're sizable houses as well. They're comparable with what he's looking to put up. Yeah.
it's going to block us out completely on the backyard. Like I say, everybody I talked to said no, but, you know, I don't know where they are.
Thank you very much.
Well, thank you.
Anyone else like to be heard on this matter? Anyone else? Seeing that there isn't any other member of the public who'd like to address the board, I'll close the public hearing and call on Vice Chairman Eisenbacher to review the correspondence we received.
Okay, on the table this evening, there was one against. We received the letter, the handout letter that's being passed that was also against. On the table, we had one in favor, but it was the prior property owner of 71 Birchwood. And I did not see any emails come through on this item.
Thank you. So we'll bring it back to the board for possible action or further inquiries of city staff or questions.
I have one question here.
Yes.
Maybe for Mr. Evans. I noticed that the zoning ordinance required that no more than 30% of the lot covered with buildings. Do we confirm that the 3,000 square foot was in compliance with that?
We didn't specifically look for that, but if we do, we will check for that as part of the review process. But I can tell you the builder's very familiar with the codes, but if that's the case, he'll have to revise.
Thank you. The public hearing is over, sir. You can have your seat.
These four people are against it also.
Okay, thank you. Thank you. Would there be a member of the board who would like to be heard? Ms. Kupa.
Mr. Motzny, the Planning Commission had worked on a woodland protection ordinance, and I believe that was also passed by City Council. Would that be applicable? Are there trees on the property that are landmark trees that would be protected, or do you not know?
I don't know the answer to that. Each development, I mean, he's proposing two houses, so I had to look at the ordinance to see if it's applicable in the first place. It usually applies to larger developments, but every development, the woodlands ordinance would be reviewed to determine whether it's applicable, and at that point, a determination would be made whether or not compliance is necessary.
That was one of my biggest concerns when I joined Planning Commission, so the woodland protection piece is an important part of whatever we can do to encourage and I don't know if that's something that if we can include verbiage to that effect when if we grant a variance.
Again, you could impose conditions on the granting of any variance. It could even involve the removal of vegetation, but again, it has to be a reasonable regulation.
Vice Chairman Eisenbacher.
I have a question for the petitioner regarding the trees on the property. If you could, yes, that shot, and a couple of the neighbors that spoke mentioned there were large trees on the property. Have you done any inventory, or could you talk to the trees on the property?
The couple of the large trees are right on the property line of between 47 and 71, probably right on the lot line. There's 2 or 3 large ones there. 2 average-sized ones in the front. I don't know if the front ones would stay with driveways being in there, but we would always try to save as many trees as we can because trees bring value to the homes. Okay. If I could respond to a couple of questions there is, the gentleman told me it's 3,100 square feet. The house next door is 28. I have no problem reducing the size of my house to, a maximum of 2,800 square feet. I want to be a good neighbor. I don't want to feel like I'm building a house that's taller than the other houses. I can reduce the size of my house, make it a little bit smaller, 2,800 square feet. Do it on that. I have been listening to the Planning Commission. I know they want to see homes for empty nesters. I have no problem with trying to build them to be first floor masters and seeing what the market dictates. I can't force people to buy it, but I'd be more than happy to try to put a 1.5 story in there that might help the elevations from a colonial on the one side down to a 1.5 story on the other to help buffer 85 being a ranch, so it's not looking at a house that's 25 feet tall. But, I can try to sell it that way, but if the people don't want to move down there in that, but I'd be more than happy to reduce my roof lines and my heights. To help 76, they're talking of their trees are moving. I have no problem planting, a tree every 30 feet in the backyard that would, in the next 5 years grow tall enough that would help buffer so they're not looking at the back of a house, but they're looking at trees in the summer and spring.
Okay, so in summary, with the 9.5-foot side,
Yes.
Would the trees on the left side of the view
They-
safe from
they
the
would
basement?
They would probably stay from the basement. I can't guarantee if they would live, once the excavation comes in 3 years or 5 years, if they die, but they would be able to stay while the basement's being dug.
Okay, so you could protect them so that the roots aren't crushed
Yes,
by the construction equipment?
by the construction equipment, but the overdigs of the basement, OSHA requires us to be 4.5 feet wide so that nobody gets injured while the basement's being dug. But as I say, we'll try to do everything we can to save a tree, because it does bring value to the house.
Okay, because item A of our list of practical difficulties includes protecting vegetation and other similar characteristics. So that may be part of a resolution. Thank
Okay.
you.
And if the tree can't live, like I said, I have no problem with planting some in the rear of the property to offset the tree that has to come down. All right, thank you.
So I'll recognize myself at this point. So even by the petitioner's own words, there is some significant opposition to this project. I know that you've done a lot of work in the south end of Troy, and you've been before this board many times. And I don't disagree with the former owner of the property saying that you do good work. I mean, I think that's your reputation, and good for you. That's good for you, that's good for the city. But what do we do with the opposition? And the fact is a want is not a area that we can consider for a petitioner or a developer. And I do think that what we're hearing from is, what we're seeing here tonight is neighbors who are in opposition, who live in that neighborhood. They have vested interests, financial and otherwise there. I used to live in that subdivision for many, many years. I used to walk my dog on that street. So when the one lady, I think the first speaker came forward, she did talk about, I believe it was her, maybe it was someone else, the characteristics of the neighborhood and really the composure of it. And the mature trees are only part of it. Also the type of homes, the size of the homes, the type of neighborhood it is. It is kind of Troy's best kept secret, very quiet, very nice place to be. So that's why I had moved in there many years ago. So since the petitioner, and this is to my colleagues on the board, since the petitioner has admitted that there is residential opposition to it, B, he seems to be amenable to come forward with some new plans. And the one gentleman who came before us, the resident in the area, asked if he could have some further communication brought forward to the board. I would just propose at this point in time that we postpone this to our June meeting, just so that the petitioner's plans can be refiled or amended with Mr. Evans and his team, and they can become part of the public record. Anyone can kick the tires and then come back to us next time. Perhaps if the petitioner does, some other work beyond PR, I'm just saying, communication about how tall the building's going to be compared to what the original plans were, maybe that opposition goes away. But I just think that it's incumbent upon us to make sure that everyone feels like they have their voice heard. And we normally don't postpone simply to hear more from residents, but since the plans in this situation are being, kind of fluid, I'm not going to say jello, but I think you did react, I think, in a positive way to say that you would be willing to compromise. So that's my motion I would like to make to postpone to the June, whatever date it is in June, for our next board meeting. Mr. Evans, can you help with that?
Yeah, checking the calendar now.
What'd you say?
Oh, third? Wait, third.
Not
20th.
20th, yes.
To June 20th would be my motion, to have the petitioner's request delayed until that time and brought up on the agenda at that time. Is there a second?
I'll second it.
Mr. Lambert seconds. Sorry, you're out of order. Any discussion on the motion that's before us? Seeing none, Mr. Evans, I believe we're prepared for a vote.
Mr. Eisenbacher.
Yes.
Mr. Katsounis.
Yes.
Mr. Lambert.
Yes.
Ms. Koopa.
Yes.
Mr. Clark.
Yes.
Mr. Agawes.
Yes.
Mr. Desmond.
Yes.
So today was 88 degrees, and next month it could be hotter, so hopefully we'll see everybody again. So thank you very much on that. Mr. Monsney?
Yeah, Mr. Chair, just to answer again Ms. Koopa's question, I actually took a look at the ordinance, which probably should have did before I answered. What the ordinance says is the woodland protection provisions apply whenever a site plan is required. This proposal is actually calling for a lot split, which would mean that there would be actually 2 single-family homes, and site plan approval is not required. Thank you, Mr. Evans. I always forget. Site plan approval is not required for single-family homes, which means the Woodlands Protection Ordinance would not apply to the particular situation. Thank you.
Thank you for looking.
Although we can, is Mr. Lambert so familiar with this, we can, in any variance approval, require certain aspects. So that is kind of, I guess, different than what you do in the planning commission, but it's definitely just added in a different way here. Okay, so we will move on from this item to communications. Are there any communications, Mr. Evans? Thank you.
None from staff.
Okay, thank you. And then we move on to other business. We are going to have a presentation from the Assistant City Attorney and also the City Attorney here in just a moment. And we do move on to item 7A, which is the election of officers. So our 2 officer positions are up every year annually, and is the vice chairman position and the chairman position. And we can take a motion for one motion for both positions and consider it. We can bifurcate those 2 positions and vote on them however you'd like. Normally, whoever makes the first motion has the floor, so you can do whichever is your favorite flavor. Mr. Lambert.
Yeah, I always think that people should have an opportunity to serve in the either role if they like, but on the other hand, I think the current incumbent chair and vice chair have been doing an adequate job, and if they'd like to serve again, I would move that we re-elect them for another term.
Can you please state names
Sure.
for the record?
Oh, I'll move that we re-elect Mr. Clark as chairman and Mr. Eisenbacher as vice chairman.
Second?
There's a motion and a second for Mr. Eisenbacher for vice chairman and Mr. Clark for chairman. Are there any other motions? We can have a competing motion, or we can move to close nominations. Is there somebody who would like to do one or the other?
I'll move to close nominations.
And I'll second.
It's been moved and seconded to close nominations for Mr. Eisenbacher as vice chairman and Mr. Clark as chairman. And if we close nominations, then the election is held at that point. So all those in favor of the motion signify by, I'm sorry, we have to call a roll.
To close.
I'm on another board too. We have different rules over there.
So this would be to close, correct?
Yes.
Okay. All right, Mr. Lambert,
Yes.
Ms. Koopa,
Yes.
Mr. Clark,
Yes.
Mr. Gauss,
Yes.
Mr. Desmond,
Yes.
Mr. Eisenbacher,
Yes.
Mr. Kaltsunis.
Okay, motion to close the nominations is approved. So, Mr. Motzi, is that all of the action we have to take, or do we have to take the?
No, that's fine.
Okay, very good.
That's fine.
Congratulations to Mr. Eisenbacher, who is an excellent public servant in his capacity. I really appreciate working with him. Now we move on to the presentation from Ms. Bloom, who is the city attorney for the city of Troy, and Mr. Motzni is going to be presenting as well, who is our assistant city attorney and our legal advisor on this board. Good evening.
All right. Thank you so much, Mr. Chair and members of the board. We always enjoy the opportunity to come and talk with you about the legal update, and we're tag teaming it tonight. But both of us are very happy to answer any questions that you have. Don't, please do not wait until the end. Ask us any questions as we're walking through. So.
All right, I think I'm going to begin. Oh, it was working a minute ago. Oh, there we go. Yeah. I don't know if anyone thought it was significant, but the first case tonight involved a street called Euclid. If anyone's familiar with zoning law, the famous Euclid case is why we have zoning. And zoning itself is a restriction on land use, but in the Euclid case, the U.S. Supreme Court said that as long as it's for the promotion of health, safety, and welfare, zoning is okay. Our ordinance, Section 1501, pretty much reflects what the Michigan Zoning Enabling Act, which is the Michigan law allowing zoning states. It says that we could have a zoning board of appeals. In fact, it says we have to have a zoning board of appeals if we have a zoning law. And essentially, what that recognizes is that zoning is for the purpose of health, safety, and welfare, but because zoning itself is inflexible, sometimes you should have some relief from the zoning, as long as that relief is reasonable. And that is the reason why we have zoning board of appeals, because they could apply their standards to promote the health, safety, and welfare, yet but maybe allow reasonable relief in certain circumstances. Our ordinance, again, is based on the Michigan Zoning Enabling Act, and decisions under our ordinance, the significant decisions that this board must make require a majority of the board to pass. So decisions on variances, interpretations, administrative appeals, they all require a majority. So there has to be 4 votes always, because this board has 7 people. If it had 5, it would only require 3, but our board has 7. So all of those types of decisions can only be passed if 4 of you agree. And so if only 4 of you are at the meeting on a particular night, you'd have a quorum, but everybody, of course, would have to approve the variance in order for it to pass. The exception is for use variances. The Michigan statute says a use variance requires a vote of 2/3 of the board in order to pass a use variance. So with a 7-person board, that would be 5 votes. Oh, with regard to voting, as you know, one of your members is the member of a planning commission. If this board is making a decision on an issue that was reviewed and decided by the planning commission member cannot vote on that particular matter before the Board of Zoning Appeals. So you would have to either not vote or have an alternative, one of the alternate members vote in that case.
So the hotel off of Wiltshire that came before us, and it came here, should I have not voted on that?
If you had made a decision with regard to that hotel before the planning commission, then you should have not voted on it. That's correct.
However, it was a 7-0 vote, and so there were plenty of votes to make that an effective vote. So we're not worried about that technical issue. Again, this is our opportunity for us to review, as well as to have all of you reviewing what the rules are. And that is an unusual provision, and so it's always good to revisit it.
So what happens if the planning commission had a meeting and they voted on something, but I wasn't in attendance, but then it came to the zoning board? Would I be allowed to vote on it?
The language does say participation, so you would have to participate in the meeting.
Yeah, I would agree with that.
Okay, thank you.
Okay.
When did we have a use variance come before us ever? Do you remember?
I think the only one I can ever recall was the old Kmart site on Maple Road, that there was some flower or something or another.
Okay, because that thing I read at the beginning of the meeting says it takes 4 votes, so we probably need to modify that for use variances requiring 5 votes.
It's a good idea.
Yeah.
That's where we have these training sessions.
Was
Oh, in the Greek church up on Waddles or something, they had their Greek festival. So there's very rare, but they do come up.
I believe there was also a restaurant that was going to be that wanted a use variance as well. I don't know if it was...
I believe, and the use variances are fairly new, and again, they should be very sparingly, used and very sparingly granted as well. But we did, a few years ago, amend the ordinance so that we do now allow them. Previously, we did not, but we do allow for use variances, but we've really not seen a whole lot of those cases come before.
We're going to discuss use variances a little bit later on in the presentation.
Yes, but first we're going to get to the whole concept of variances, and I've said this to you all when I've done the training, and I'm going to say it again. Really, what you're doing is it is an excuse to, it excuses somebody from complying with the law. When you grant a variance, they do not have to comply with the law. It's permission to break the law. So because of that, you should be very sparingly granting your variances. And you should be very rigorously applying the standards. Because if you don't do that, you're undermining your own decisions, you're undermining our ability to protect your decisions and to defend your decisions, and you're also undermining the ability to enforce the zoning ordinances. So you really should be very, very cautious when you're giving a variance, and you should really make sure, again, you don't have to comply with all of the standards. I think earlier, Mr. Eisenbacher, you said, I think it was you or maybe Mr. Lambert that said 3 of the 5 were satisfied. That's sufficient, but you need to make sure that they're truly satisfied. And so we're going to go into that in just a little bit. And just the last thing on the slide is just dimensional variances versus the use variances. And we're going to, we've talked about the use variances already. Dimensional variances, you know what those are as well. It's relating to setbacks and things of that nature. Dimensional variances, again, you know this, you granted, you were thinking about conditions, the conditions about, moving the property over with the last one, the one on Birchwood. Those are, things that you can incorporate with your resolutions, but I would just caution you that if you're doing that, make sure that you're very clear in your resolution what the requirements are, because it needs to be very clear for anybody who is looking at it afterwards, because that will be the record, that will be the requirement. So if you are going to change a setback requirement, which you can do if it's reasonably related to the variance, you need to make sure that it's very clear where, what you are actually trying to accomplish. So, you should use direction, you should say on the east side or on the north side, or, you should really be very clear in defining exactly what those conditions are. And another thing, too, is that your variances should be, first of all, you shouldn't be granting them unless there's something that is related to the land itself. But secondly, you also should be granting only the minimum amount of a variance that is necessary. And so that is something that you do have some power to do. If, for example, let's just use the first, the Euclid site plan. Again, very good questions about how big is it, how long is it? 25 foot is what they were looking for. Well, 17 foot, he said that it would be too narrow. Well, maybe 20 foot is okay. Maybe, you require them to go back. Maybe 20 foot would, be less of an impact on the neighbors. And that's another thing, too, is that you should also be looking at the whole neighborhood. And although the property in the back on the Euclid was a single-family home, and right now it was not developed, I think you have to assume that there probably will be development in the future, because we're seeing that all over the place. We're seeing development everywhere. So you've got a piece of property that could be very close to a home that could be eventually constructed. I mean, they could tear down that one single-family residence and they could put a number of other homes there. So you need to be thinking about the neighborhood as it is now, but also you need to be looking a little bit into the future as well, and to what the possible development could be in the future.
Ms. Bloom? I have a question. Back to your statement regarding conditions and getting those in the motions. If an applicant either offers that they're going to do certain things, whether it's in their application or at the hearing, do those necessarily, especially when they're speaking, do those necessarily all need to be put in the motion? They would still apply even if they're not in the motion? Can you talk a little bit about that?
Yes, and again, I thought that it was admirable of Mr. Abatheria to agree to make some changes. I was very carefully listening to what his language was, though, and he said he's going to try and save the trees. He didn't say he was going to save the trees. He said he was going to try and save the trees. So in order to protect against that, you need to say that if you're going to do this, you need to preserve these trees, and you need to take measures that are going to be far enough away from the tree so that it is not, so that when you're digging your basement, it's not going to be impacting the trees, and you're trying to preserve the trees. So yes, I think it does need to be in the motion itself. If you need to take some time to craft a resolution, you can do that. You can always take a recess and try and think about how it is that you're going to craft that resolution, because again, it's made from the table. I always hate to have motions made from the table because you never, you're kind of thinking on your feet, and you may not think about everything that you would if you had some time to really think about it and to craft a resolution. So if you need some extra time, you can ask the chair for a recess, and you can take a recess, and then you can write it out on paper and then have it read. But yes, I strongly encourage you to put it in the resolution, because statements that are made are not part of the record. So you have to have it in the resolution in order for it to be binding. It has to be in the resolution.
Let me ask another question related to that. I know City Council, from past experience, when they would have a similar situation, they would direct city staff, sit down with Mr. Abatheria and come up with a plan that reflects what we'd like to accomplish so that we avoid trying to make a solution up here. Is that appropriate to do that with Mr. Evans and say, sit down with Mr. Abatheria and come up with a solution?
I thought you had a great solution in postponing it and coming back, because there were too many things that had to be done in that particular case. And so perhaps you can meet and try and craft some language. I'm sure Mr. Motzny would be very happy to help with that. But yes, I mean, I think that, again, that particular situation, time is not necessarily of the essence. If time were of the essence, you might try, and I don't know what that situation would be where they had to move quickly, but it could happen. And if that's the case, then you might just take a recess here and then just try and craft a resolution at the table. But generally, it's unfortunate that you only meet once a month, because it's a whole month of a delay. But most of the developers are going to have some time built in and can withstand that, especially if they're going to ultimately get the relief that they're requesting, which you otherwise may not feel that they have satisfied the standards to be able to grant it. Okay.
If I could just really quickly kind of go back, maybe we're going to beat this one up too much tonight, but regarding 71 Birchwood. So your point is well taken about, that the developer has to do whatever he needs to do to protect those trees. And his pushback, well, I don't know what's going to happen in 2 or 3 years. Well, we don't know if there's going to be a flood tomorrow. You can't protect against every unknown. But we could, in that situation, and I know we've done, like the church on Adams Road, where we required some planting, which was not there. It was just a greater screen. But these are specific trees. We could say, protect those, do what you need to do to protect those mature trees. And if there's an accident and or error, then a similar type of tree would have to be planted in its place. The same number of trees and so forth, correct?
Correct. And that you should have a limit on the time. You shouldn't go beyond probably 2 years. I mean, 2 years is probably, he may be, even balking at 2 years. But certainly that is a very appropriate condition to, if it's going to allow you to grant the variance that they are requesting, and also allows you to maintain the character of that neighborhood and preserve the natural features, then you can require that if something happens, that they take all measures necessary to protect the tree and the landscaping, and then if something happens to it within a 2-year period from the date of the motion, then they will replace any trees with similar caliper, and then, again, I would throw in something about subject to the approval of the planning department or the zoning and compliance specialist, so that you have somebody administratively that's kind of looking at that and seeing it.
Okay, thanks.
Okay? All right. And sorry, I'm going to just go, the one thing I wanted to do, sorry, Ellen. I think it's important that we go over these, and I know that you know these because I know that you see them every time, but I want to really focus on that it has to be related to the physical premises. And it can't be of a personal nature. I remember many, many years ago when I was serving as the legal advisor to the ZBA, and we would have people with medical conditions that would need a sunroom or would need a back room for medical conditions. That is not related to the physical premises. Related to the physical premises is an unusual, like a ditching situation, or it's a very unusual shaped parcel, not because the owner divided it up and did a lot split and made it an unusual parcel, but it's just a very unusual parcel. Or you're preserving, landmark trees that have been there for years. Those are the types of things that are physical characteristics that you should be focusing on. You should also make sure that it is not a hardship that is created by the owner or the previous owner. And also you do, again, as you know, it needs to not be harmful to or alter the essential character of the area or diminish the property value or impair the public health, safety, and welfare. That last one, the public health, safety, and welfare, that's kind of the catch-all, but that's kind of your, that's probably the most prevalent thing. That's what your job is to protect the public health, safety, and welfare. So it's probably the most important one.
Question for you before we move off that slide. Can you elaborate more on the third point?
Yeah. Not of a personal nature?
Yeah.
Okay, so that would be, the personal nature would be like the medical condition, or the person is bringing in their in-laws and, they need an in-law suite or something. That would be of a personal nature. That's not related to the property itself. It's related to the occupants inside and what they need. And so you shouldn't be basing your decisions on that. Also, you should never, ever base your decision on a financial hardship. Financial, it does not rise to something that justifies a variance to be granted, a financial reason.
So like if I had 4 cars and I wanted an extra garage, because I'm a car person.
That would be a personal nature, and so I would argue that would not be something that you should be, I would strongly advise you not to grant a variance in that particular case. Yeah.
Okay, so with that first item on our agenda, there was also an additional bathroom in the plan. What if part of the health, safety, and welfare was to have better sanitation in the house?
You really need to not stretch it too much. You really need to be very true to what those characteristics are. And I understand, I get it. You guys are faced with people who come in, they want this, they didn't realize that they couldn't do it when they bought their house. But you need to be very careful to enforce the ordinance as it is written, because if you don't, and I think Mr. Motsney can talk to this, but if you're granting things based on the number of people who are present, or you're granting it based on the fact that there's nobody that's opposed to it, then it's going to be very difficult to defend an action when we get sued later on, because you're inconsistent. So by following these and by being very true to them and not not kind of, if I'll say gerrymandering, by not doing that, you are making the ordinances more enforceable, you're making your decisions easier for us to defend, you're also providing uniformity, and you're providing consistency, and you're preserving the property values for the city of Troy. And another thing too, sorry, I'm on my soapbox now, you guys are going to be sorry you gave me the microphone, but just be also very, very cautious. When you grant variances, there is an impact to other properties. So once you grant one variance, then you're going to be faced with a similar, a neighbor who wants to do the same thing. Now, it was a good question earlier about the house on Euclid. Have any of the other neighbors received a variance? That was a great question, because I thought that they may have, and again, that would have been harder to deny if that were the board's intent, if other variances had been granted, because it does set a precedent. So, okay, I'll let you talk.
It's all right. You can keep on going. You're doing a great job. Actually, before we go into use variances, Lori mentioned it's a problem if you grant too many variances, and we have a situation actually right now involving a lawsuit involving our sign ordinance. And it doesn't involve this board, it involves the Building Code Board of Appeals. There's an allegation in this sign ordinance case, which is based on the First Amendment, that our ordinance standards have absolutely no meaning. And in support of that, they cited all the variances that have been granted on the sign ordinance by the Building Code Board of Appeals, and says because it's so easy to get a variance, they're claiming that our standards there's no specific standards, and they're challenging our ordinance based on a board of the city granting too many variances. So they can come back to haunt you, and you never know when it's. So we're dealing with that, and we're defending that, and hopefully we'll be successful. But going on to use variances, like Mr. Eisenbacher said, you may never have to even consider a use variance. And in fact, our ordinance has specific procedures for use variances that actually require a pre-development meeting with the people asking for a use variance. I'm not going to get into that, but if you ever have a use variance before this board, trust us, we're going to have a lot more information to guide you through it. But essentially, a use variance is asking to use the land for something that's not permitted, asking to use residential property for a commercial purpose, or so on and so forth, or business property for an industrial purpose. Basically, you're asking for a variance to change the use of the property, and they're not favored in the law. In fact, townships and counties in most cases aren't even allowed to grant use variances. However, cities have that authority. But when a city grants a use variance, before a board could grant that, they have to essentially determine that the applicant has presented evidence that the property cannot be reasonably used under the zoning ordinance. And that's really a heavy burden. And in most cases, when you're dealing with a use variance, it shouldn't be granted unless they bring some sort of expert witness, like a planner or some zoning expert. And in those cases, you're allowed to ask for their resumes, you're allowed to ask questions, or we're allowed to bring experts on our own behalf. So use variances are a whole other animal, but the essential thing that has to be shown is they can't use the property for any reasonable purpose as zoned. Again, the condition or situation for which you want a use variance has to be unique. And this is an interesting factor. I should go back. What the statute says, the Michigan Zoning Enabling Act says, in order to be entitled to a use variance, you have to prove that you have an unnecessary hardship. Now, that's all the statute says. But what constitutes an unnecessary hardship has been defined by case law, and the case law that defines an unnecessary hardship is what we put into our ordinance. Not being able to use the property for any reasonable use. It has to be a unique situation. But one thing they have to show is that the land conditions make it impossible to earn a reasonable return without adjustment. And the reason I mention that is because Lori just told you that a financial reason is not a good reason for granting a variance. However, actually case law with regard to use variances actually indicates that you can consider financial reasons if you could show that the present zoning would not allow a reasonable return on your investment. So there's sort of an exception to the general rule, but that only applies to use variances. Again, you can't say, well, I'd make more money if you gave me the use variance. That's not a reason. But if they can present expert evidence showing that they cannot make a reasonable return, that's one of the factors you can consider with the use variance.
Just for my clarification, are we talking about, like, for example, if we had a residential property on the corner of a node and it's basically nobody wants to purchase this property because it's residential, it's right on the corner of a major node, and somebody purchases it and tries to convert it to commercial? Is that specifically what we're talking about?
That would, yeah.
Okay.
If it's zoned residential and they're asking for a commercial use, that would be a use
All right, I
variance.
just wanted to make sure.
Again, you have to determine that the variance won't alter the essential characteristics of the neighborhood. You have to get a use variance, you have to show that there's sufficient capacity, roads, utilities, drainage has to be appropriate for the use you're proposing. And as with dimensional variance, it can't be a self-created hardship.
And so with that, just using your example of if they purchased the property and they knew that it was not, that there was not a whole lot of activity on there, if they purchased it for a lower price, obviously that's a self-created hardship. So, so again, that's maybe an example of where you need to, it's one of the other ones, if it's not a reasonable financial return, you also need to see if it's a self-created hardship.
Okay.
I think we move on. Variances in general, a request for a variance has to be applied for by the owner of the property or the owner's representative. And a lot of this, you can't grant a variance without a public hearing. That's all required by the Michigan Zoning Enabling Act as well as our ordinance. We've discussed this already tonight. You can impose reasonable conditions as long as there's valid health, safety, and welfare reasons for those conditions, and it's based on the land itself. The condition has to be related to the use of the land. Variances run with the land. If you grant a variance, it's a permanent thing. It will be every person who could use the property from now on, if that variance is granted, they're entitled to that variance, and that's why you can't grant variance for personal reasons, because it has to be based in the land, because it runs with the land. There's no right under the Michigan Zoning Enabling Act to ask for a rehearing under when the variance is denied. However, the act does allow cities to allow rehearings based on whatever they put in their ordinance. Our ordinance indicates you can't ask for a rehearing for at least 1 year unless there's a substantial change in evidence. So once it's denied, you can't ask for a rehearing generally.
And a substantial change would be like a completely different site plan, or, I mean, it's going to be something that's just more than just, eliminating it by 3 feet, reducing it by 3 feet.
One of the things this board has the power to do is an administrative appeal. This board can review any decision of anybody that involves the enforcement of the ordinance. The typical administrative appeal would be if somebody is denied a building permit from the building department. The person denied can make an administrative appeal and ask this board overturn that decision. It is, again, the burden of the applicant to demonstrate that the building official made some sort of error in law in the interpretation of the zoning ordinance in denying the permit, and it's a pretty tough burden. The last case I actually remember where we had an administrative appeal, and maybe a lot of you remember, is the Monster Garage case. There's this huge garage. Mr. Piscopo was the owner.
Yeah.
And Mr. Piscopo applied to build this huge garage attached to his building, and our building official looked at his application, and he looked at our law, and he said, I have to grant the permit. He's complied with our ordinance, so he issued the permit. Well, a lot of people didn't like the monster garage, so and that's another, I'll get to that. Anybody who's aggrieved by the decision of this board can appeal to this board. Anybody who's aggrieved by a decision of an administrative official can appeal to this board. So a bunch of neighbors appealed the granting of the permit. And we had a big hearing, it was on TV, and there's lots of people here, and this is kind of an important fact. Our ZBA, they overturned our building official, said you can't have the garage. And I'll get into this later, but then Mr. Piscopo sued us, filed a claim of appeal, and the judge looked at our ordinance and said, the building official was right. There's no reason based on the law, he should have granted the permit. And the point is our ZBA was probably acting a little bit on emotion. They didn't apply the law, but because if you looked at the law, the building official was right. So the court overturned the ZBA and reinstated the decision of the building official, and that's why he has this monster garage. Of course, we've changed our ordinance since then to not allow that. But that's the point being, you have to base your decision on whether or not the building official properly applied the law. And another point I should mention, if there's an appeal from this board, our office will represent the decision of this board. Right or wrong, we're going to defend your decision, because in that case, it was our building official, who also was a city employee, but the last decision of the city of Troy was made by this board, so we represented the interests of this board at court, even though we lost, but just so you know, that's our job to represent your decision. So hopefully you make good ones so they're easier to defend.
And we are going to represent you. We're going to try and get your decisions upheld. And that's why it's really important that you make records and you say the reasons why and you really stay true. If you can articulate how you're following the standards, then more likely than not, we're going to be able to get your decisions affirmed. So it's just important that you do communicate and help us to do that. So, and I know, Mr. Eisenbacher, you had a question.
So again, in that opening statement that I have at the meeting, we let the applicant know and the people know that they can appeal our decision to the county. Does the city let people know that they can appeal the building code? How would a person find that out? Or appeal the decisions of the building department?
I don't know if anybody tells them that when they apply for a permit, but if they look at the zoning ordinance, that's in there. That's correct. So, I'm sorry.
And I'm only aware of that one particular situation where we've had an appeal where our internal building department person had a disagreement. It was overturned actually by the ZBA, and I've been here for over 20 years, and so that's the only thing I can remember.
I think the next slide is, yeah. This board has the power to interpret the zoning ordinance and to interpret the zoning map. The last interpretation I recall is the property on Rochester Road, the former Marinella's, maybe some of you were involved. This board was asked to decide whether it was a community center, a place of worship, or a club, because depending on how you classified the property, different zoning regulations applied. And so sometimes this board may be required to actually make an interpretation of the zoning ordinance. And in doing that, you have to consider the intent of the ordinance. If you're making, if you could only make an interpretation if there's absolutely, if it's ambiguous is when you can make an interpretation. But if it's clear what the law is, then of course there would be no ambiguity. You can make determinations based on the zoning map. I don't ever recall that ever happening in Troy, but that would be somebody thinks they're in residentially zoned property, but our records show it's zoned commercial. If it's really close, this board can actually make the call whether the property is in the residential or the commercial zoning. Of course, there's some standards that apply. If you look at section 4.03, it talks about zoning map interpretations, and this board would have to follow those standards. Again, if we ever get to one of those situations where you have to make an interpretation, obviously, we're going to have a lot more information for you to guide you in such decision.
And that's important to know as well, because, again, as Alan had mentioned earlier, it's not just the language in the statute or the ordinance. Sometimes there are cases that interpret what the statute means. And so we will have the opportunity to read all of those cases and to provide some advice to you. And it may be in a confidential memorandum. It may be in a public memorandum. We're going to talk about the ability to do confidential memorandums in a little bit.
The next item is an appeal of this board's decision. Under Michigan law, again, the Michigan Zoning Enabling Act, any person aggrieved, that's the word the statute used, as aggrieved by the decision of this board can file an appeal as of right with the circuit court. So that's not only those persons who are denied a variance, but if you grant a variance, a next-door neighbor could argue that they are aggrieved by this decision and they could appeal. And I would point out it's actually much easier for us to defend a denial than it is to defend a granting of a variance, because as you are aware, to get a variance granted, they have to establish 5 criteria. And it's hard to defend that sometimes. Whereas a denial, if you find they just don't meet one criteria, you could deny it. So denial is much easier to defend at circuit court. An appeal must be filed within 30 days of the written decision of this board, or 21 days after the minutes are approved for the meeting where the decision was made. And that's usually the standard that is applicable. The circuit court, their decision, they don't stand as a super zoning board. The circuit court actually looks at the record on appeal, and they could affirm this board's decision, they could reverse it, or they could modify it, or they could remand the case back to the ZBA for findings of fact. And that happens a lot. The circuit court sometimes looks at the record on appeal and says, I need more information. The ZBA has to make more specific findings of fact. But the point being is they're not actually deciding the variance. What they're actually deciding is whether this board's decision complies with the law, is based on proper procedure, that the decision is supported by competent material and substantial evidence on the record, and that it represents reasonable exercise of discretion granted to the ZBA by law. So that's what the circuit court's deciding. And as you may be aware, we have a pending appeal at the circuit court right now on the hotel case. They filed an appeal of this board's denial, and we're just getting involved in that one. So.
And that is one where, again, we are going through, we are getting the record of that, and we'll go from there. But it is a great example of where, again, we're hoping that you are, complying with all of the standards. Another thing too that I wanted to mention, it's the applicant who has the burden of proof. And so sometimes you may want to help them because you have people that aren't familiar and they're not as sophisticated, and they aren't really aware of what they need to be asking for. But it is the applicant who does have the duty to show that there is a hardship, and they have the duty to show that there is competent material and they have the duty to produce the competent material and substantial evidence. So you should always bear that in mind. If they're not doing it, you can ask them some questions to get them to demonstrate, and it's difficult. You guys have a very, very difficult job, and I completely understand that, especially you, Mr. Chair, because you sometimes bear the brunt of trying to get them to focus in. But they do have the burden of proof, so please try and hold them to that burden of proof. And that was,
I have one question, and if it's going to get in trouble as far as the law case is concerned over the hotel, then you don't have to answer it. But During the course of that hearing, there were some heated exchanges between one or two members of the zoning board with the applicant. Is that something that the applicant is using in their lawsuit?
They haven't, they don't mention that in the claim of appeal, but they haven't filed their brief yet. They seem to be focusing on, just based on what they filed so far, the decision that regarding the self-created hardship. That seems to be the one thing they're focusing on, that because this board decided that the reason for the variance was caused either by the applicant or its previous owner. And if that's the case, the variance could be denied, and that's a good denial. That seems to be the one thing that they're focusing on. But again, they haven't actually filed. There's a whole procedure. We have to file the record on appeal, and Mr. Evans is actually working on that right now. The court's going to get everything this board has. They're going to get the notices, the minutes. They're going to have a video of the meeting, so the court will have the video, and the court will watch it. Well, they should watch it. Whether they actually do it or not is another question. And then after the record on appeal is filed, all that material, then they actually file their brief on appeal, which is their legal argument as to why this board was incorrect. And then we get to file our responsive brief as to why you guys did an excellent job and they're crazy for even appealing. And we won't use those words, but something. And then there's a hearing where we have an oral argument and we present our case, and then the court makes the decision. So.
But I'm glad that you did kind of bring that up, because that gets into the second part. So we've kind of covered the zoning basics and kind of the variances and things like that. So if there are any last minute questions on that part of it, I'm happy to entertain them. Okay, a couple more, okay.
Okay.
Go ahead.
One thing on the second item before us this evening is, if you look at the original plating, the original zoning, it was actually 3 lots, not just 2 that he's asking for. And it's a bit of a hardship if the zoning ordinance used to allow it, and now the new zoning ordinance doesn't allow it. And it's not really clear how much of a hardship that is, if that's a legitimate hardship or not a legitimate hardship. You have any thoughts on that?
Yes, that is one where, again, the plating, that is an appropriate thing for you to consider. Now, again, he did purchase it. He admitted himself that he knew, I mean, he didn't do his due diligence. He did. He missed it. And I think he would admit that he is, I think he's nothing if not forthright. But yes, the fact that, it's not the fact that he bought it, it's the fact that there are other parcels in that neighborhood that were developed originally under the old plat. So the lots are smaller. So perhaps that could be a justification of a hardship, if he is able to articulate that. Again, going back to, if a plat does change, then again, perhaps that is a good justification that you could rely on, again, assuming that everything else is satisfied. And it's not just the one thing. You have to see, look at more than just the one item. But yes, that is potentially something that you could rely on.
So my question was, you said in one of the previous slides, you said consider the master plan. Mm-hmm. Now, is that something that the planning department could come back and provide training to the ZBA? Because I don't know how many people, it's like a 345-page document. I've got a binder sitting at home that when I want to go to sleep, no, I'm kidding. It's a very interesting document, actually, because it outlines, I don't think we did a complete rewrite of it last year when we approved it, but it's a good document for everyone involved here to look at, or at least have a general understanding of.
I'm hoping that you all have a copy of the master plan, or at least know how to get it on the city's webpage. All of you, I think, know how to get it on the city's webpage. I encourage you to do that, absolutely, because it is the governing document for how City Council foresees the development occurring in the city and how they would like it to occur. So again, I think that's a very valid point. We really do want you to know what the master plan says to to be familiar with it. As far as training, I would defer to Mr. Evans on that and to see whether or not there can be training on it, but certainly it is accessible on the city's webpage, and encourage you to definitely look at that. Okay.
Just to comment really quickly on your conversation with Mr. Eisenbacher. So there may have been 3 plats. He purchased it under a new system. And, you know, to me, we just got done thoroughly looking at the characteristic of the neighborhood perspective, which those homes in that neighborhood are small, by and large, you know, and so that would cut against, you know, that angle, you know, regarding any potential approval. We don't know what his future plans are coming to us, but I mean, I think everything you've shared so far has been excellent. I really think that sometimes is overlooked, the characteristic aspect of neighborhoods, because I've been on this board for a very long time, and we don't really talk about that enough, I think, because that's when you have neighbors show up, you know? This is their neighborhood, and they want to keep it as, essentially as it was. And then the other thing is just really briefly, on the Marinelli site, because I was on the board at the time, of course, it was just, what, a year ago or whatever, and I think you made a comment unrelated to the Marinelli site earlier about keeping focused, and I think in that one circumstance, if a member here wasn't here for that, that was the one thing where you have to look at the whole picture, not just what the piece of paper the applicant's coming forward, because there were all these other ancillary postings on the internet and so forth. So I think rightly so, this board took that bigger picture and stayed focused on really what is the project going to do, not just what did the applicant pitch to us at the microphone and write out on a piece of paper. It's sometimes they don't put everything on that piece of paper.
Right. And again, thank you for bringing that up, because I think that is one of the success stories of the ZBA. There are many, but that was a very difficult situation, and it was very difficult to get through that, and I'm very proud of how that whole thing came out. And again, now we have the Nihis there, and I think that was a good result. But because the work was done, because all of those steps were taken, because everyone was focused on the bigger picture, we were able to get through that, did not have a lawsuit, which, you know, again, we don't like lawsuits, so, you know, they happen sometimes, but we don't like them. So, again, kudos to all of you, and I think a number of you were on the board at that time, so kudos to you. And again, if something like that does happen, we certainly are going to be involved in it, Mr. Evans, and our department. We're going to try and make it as easy for you as we can. We're going to try and do as much of the legwork as we can. Obviously, you get the discretion. We just provide advice. So, but yes. So anytime that something like that happens, or you see that something is coming, and if we're not aware of it, please let us know, because we're always happy to help out. We're always happy to provide the advice, and love to get the questions beforehand rather than having to respond to them at the meeting. So anytime you can do that, we certainly do appreciate that. So I'm going to just move on just briefly to the Code of Ethics, and all of you have signed a Code of Ethics. I'm not going to go into it per se, but Mr. Lambert, you had asked about you know, the demeanor of that particular meeting and whether or not that was something that was cited in the lawsuit. It isn't yet, it may be, but that is something that you need to be concerned about, because if maintaining a professional decorum is going to provide our residents with a sense that you are a fair and impartial board, that you are not biased, and that you are taking your responsibilities seriously, and that you are listening to all of the residents. And if you deviate from that, and I understand, you know, tempers can flare sometimes, but it is really important that you try and maintain proper decorum at all times, because again, you guys are representatives of the city. You are city board members, and so I encourage you to do that. If tempers are flaring, we're going to give you some tools as far as maybe how you can address some of those situations. Because I understand it happens, and mostly it's because of neighbors who don't understand the whole process, and so again, we'll talk about some tools, but just to touch on the Code of Ethics, one of the things that the Code of Ethics requires is, to again, encourage all of the members to be able to express their opinions, to allow the residents in an orderly fashion to come up and to comment, and also just, again, to respect confidentiality of privileged information, and to also recognize that you speak as a body. So you speak through your resolutions. No one member can represent what the ZBA is going to be doing. So, rendering all of your decisions based on what's presented, that's very important. I'm guessing that you go to site visits sometimes. Do you go to site visits? And when you're going to a site visit, I'm hoping that you don't engage in conversation with the applicants, because what I really would like for you to do, and I want you to blame it on us, and say that we've told you that we would like you to bring your information, whatever information you have, applicant, neighbor, bring it to the ZBA, because we want every member of the ZBA to have this information. So that's why you encourage them. I encourage you not to get into those conversations, but to tell them, to communicate with you. You can do it through email. You can do it through a written, document. You can come and talk if you want. But that way, all of you have the same information. If you don't do it that way, if you come back and then you're in the position of having to say, yes, well, I talked to the neighbor and the neighbor said, this to the rest of the board members. And we all know that sometimes that, may not be an accurate rendition, or you're trying to interpret what the neighbor was saying. So again, anytime that you can, I encourage you, again, do the site visits, politely tell them, thank you, I'm just looking, and I'd like you to come and present your information to the ZBA as a whole, because that way all of the members will have that information. And I think it makes you a better board as well, because you all are armed with the same information. So again, that's one thing, and blame it on us. Tell us that, say that we insisted on that. And then just, these are things that avoiding conflicts of interest and the appearance thereof, and I think all of you are really good at that. Err on the side of disclosure always if you think that you might have a conflict. If you're a neighbor, if you're, err on the side of disclosing it. The board can decide whether or not they think it would disqualify you. If it's a question that you have, you can ask Mr. Motzner or I. If you're not sure if it's a conflict or not, we're happy to talk with you about that. We're also happy to help you with the procedure, how you would go about, bringing that matter up. And then the last one, getting back to your point earlier, avoid the use of a derogatory or denigrating language. We have seen where, and I'm not saying that it's happened here, but it has happened in other boards and committees where there has been derogatory or denigrating language used. And that does a couple of things. First of all, it creates a little bit of confusion. It does make people think that you're not listening to what they're saying. It makes them think that you're biased somehow. It actually creates probably more, sometimes when we're in defensive postures, we don't really listen that well. And unfortunately, that happens when derogatory or denigrating language is used. So again, I know it's difficult and I know sometimes it's out of your control, but just again, be professional and remain professional at all times, and that will serve you all very well.
Talk about conflicts of interest. I mean, the general rule is this: if there's a conflict of interest, you shouldn't vote. But that's easier said than done, because there's really no law that says if this exists, you have a conflict of interest. So what do? We have to look at other laws to kind of decide what a conflict of interest may be. The Michigan Constitution, it's a conflict of interest if you're involved voting on a matter where you have a contractual interest. Clearly, if someone before this board is someone you have a contract with, that's a conflict of interest, and you shouldn't vote. Go on next. There's statutes in Michigan that kind of defines what constitutes a conflict of interest, but the general rule under the Michigan law is if you have a pecuniary interest in the outcome of the decision, in other words, is it going to affect you financially, that's clearly a conflict of interest, and you shouldn't vote on that particular matter.
Another thing, too, is if you are the neighbor to a property or you are in the back, if you are directly adjacent to that property or very close, that might be a conflict as well, probably is likely to be a conflict, so be aware of that as well.
Question. Is that the 300 feet that we do notifications, or further than the 300 feet, would you say?
It's really, there's no defining line. And again, the next slide is what we say, when in doubt. Like if you're 400 feet from the property and maybe it's not a big deal to you, but then on the other hand, someone might think, well, I'm kind of close to that, it might be a conflict. The best thing to do is to disclose it to the board. And you might even say this, say, I'm 400 feet from this property, I don't think it's a conflict, but you guys, what do you guys think? And if the board can vote, if they agree that it's a conflict of interest, then that person shouldn't vote. And when that occurs, what we recommend is the person who was determined to have the conflict, we actually recommend you leave the room completely and not be involved in the discussions whatsoever. There's no law that says that, but that's just to avoid the appearance of impropriety. It's best just to leave the room.
And there's nothing worse than somebody later on discovering something that was not disclosed, and then they think, they're going to assume that that was the reason that you voted that way is because you had some personal connection, because you live 400 feet away from the property. So you want to just put it out there up front and just make sure and say, listen, this is the, this is truth here, and see what the rest of the board thinks and whether or not they think that it's going to be a disqualifier. I've already talked about the duties of officers. Just on this one, just also, the maintaining professionalism and decorum also applies in electronic communications. So make sure that if you are doing electronic communications with an individual, which I, again, encourage you not to do, I encourage you to take the information and forward it to Paul so that he can forward it to all of you. But again, just be aware that your written and telephone conversations, you should exercise that same amount of decorum that you would here in the council chambers. And with that, I'm going to talk a little bit about the sunshine laws, and a lot of you have heard me say this before, but sunshine laws we get from the post-Watergate, 1977, and again, the purpose of the sunshine laws was to inject sunshine so that people can see what is going on with government. They think that better decisions are made when they know what the government is doing. You guys are all a public body, so you are required to comply with the Open Meetings Act. And so the Open Meetings Act, I'll let you, So basically, all of your meetings have to be open to the public and have to be in a place available to the public. So notice that the doors are open, and I'm so glad that they are open. Sometimes it does get noisy, if you have a lot of people here. If it gets noisy, the one thing that I would ask is that there is a sign in the back that says, "Meeting in progress, please enter quietly." Those doors should not be shut without that sign being up, because you want people to know that they can come in, because otherwise they might not feel like they could do that, and you want to have your meetings accessible. So, so again, try not to shut the door if you can avoid it. Also, make sure that the doors, you notice that the doors were unlocked to the building on both sides. If you ever get here and you see that the doors are not unlocked, please let us know, because we want to make sure that that is. So let Mr. Evans know, or let our office know, and certainly we will make sure that the meetings are available. There are a couple of things. I don't know how many grand openings you guys go to. As long as you're not talking about the business of the ZBA, then it is not going to be something where you have to comply with the Open Meetings Act. But one thing that you do need to be very concerned about are email communications. And I think Mr. Evans is putting on all of his now that please do not reply to all because it could be an inadvertent violation of the Open Meetings Act. You have to notice every meeting, and you can have, you wouldn't notice an email communication because you don't think of it as a meeting. But there have been new lawsuits that, and new cases that have said, absolutely, an email reply to all where you're interacting, it is a meeting and it's going to violate the Open Meetings Act. So please be very mindful of that. Just remove that reply to all button from your computers and don't use it at all. You can go to an educational session. Let's say that there's a training session. You can all go to a training session without complying with the Open Meetings Act and noticing it. You just need to make sure that you're not discussing or deliberating the business. Another thing, it's a little difficult sometimes to get business done and you're not sure how people are feeling on things. You can do what's called a round robin. Like, let's say that the chair would be calling some of the members individually to kind of just get their pulse on how they might be thinking or if there are issues that they might have with a particular matter. What you can't do is communicate what A, B, and C are. You can't communicate what everybody else is doing. So one person can gather information from a number of different people, but you cannot disseminate what that information is without violating the Open Meetings Act. Is that, okay, all right, good. Okay, so.
Oh, Mike.
Yep, yeah. I think we talked about most of this.
Yeah, I think we discussed a lot of this already, but, I mean, like Lori said, if it's an open meeting, it has to be open to the public. One thing we have to do is make accommodations if we're going to have a big crowd. If you know we're going to have a big crowd, there's not really another room we could move to, but we can make accommodations. We could set people up in a conference room, for instance, and show the meeting on video. So in those occasions, we have to make sure everybody has the availability to participate in the meeting. Anybody who is at an open meeting has the right to address this board, but this board can adopt rules. For instance, we could make sure that all public comments occur at a particular point on the agenda. If it's going to be a particularly busy meeting where a lot of people are going to speak, we can make rules and limitations on how long each person could speak, as long as those rules are communicated by the chair at the beginning of the meeting. We can't limit the subject matter that somebody wishes to talk about. And so sometimes if they're saying, so-and-so made a really bad decision on the board, well, you're going to have to take it unless it gets to the point where it's defamatory or slanderous, but you can't put a limit on what they can discuss.
And the other thing too is they could discuss something that you have no jurisdiction over it at all. It could be a city council matter. It could be a school board meeting. It could be a school board matter. You can't stop them from giving public comment during the public comment portion of your meeting. Also, you do have to have the public hearing portion as well, and you're obligated to have that. And just one other thing too is Open Meetings Act also means that they can come in, they can record, they can bring in a stenographer, they can video it, they can basically do whatever they want. When it's an open meeting, we truly mean it's an open meeting and you can record it in any fashion. So just be aware of that. If you do have somebody that does that, because they're gearing up for a lawsuit usually, we can't prevent them from doing that, and the good thing is we'll eventually get the whole transcript of the proceeding as well.
I think we discussed a lot of these already, but what comes up sometimes is somebody is sitting here and they're being disruptive or unruly. And you can remove, the chair has the right to remove somebody if they cause a breach of peace. We do recommend that you give some sort of warning first. And if they don't heed the warning, you can ask somebody to leave the meeting if they are disrupting the meeting and causing a breach of peace. Years ago, we actually got sued when the city council limited the comments of somebody because they were being disruptive. And just so you know, we won that lawsuit in federal court. But in that case, the mayor gave reasonable warning, based the decision to have this person stop speaking on the rules that were established. And as long as you do that, then that is appropriate. I think we've discussed most of this already.
The other thing too, just be very, very careful. You do not want to have it appear like you are censoring public comment based on what they are saying. So you don't want it to look like, you know, if somebody was opposed to a variance, you don't want to, you don't want it to look like you're not hearing from anybody who's opposed. You just want to hear from those who are in favor of it. So the content, it's very important that you treat everybody equally. And again, the chair giving that comment at the beginning of the public comment and saying, okay, we're going to limit it to 3 minutes, it conveys that, yes, we're not discriminating based on content. So, and again, as Alan said, we can't really protect you. Sometimes you're going to be criticized. We wish that we could, but as long as you're doing your job, and as long as you're maintaining that professional decorum, you're going to be fine, and we'll hope that it's not too scathing. So, and if it's relating to your performance as a ZBA member, we really can't do anything about that. We wish that we could, but unfortunately, it is an open meeting, so they can talk about anything. Closed sessions, I think we've maybe done one, I think with the Rochester Road property. It's very unusual that we would do a closed session, but there may be an instance where we need to do a confidential memorandum, and we need to talk about that, and we don't want to have that occur in an open session. I don't want to convey to opposing counsel what my legal advice is, and especially if I'm saying, there's a 90% chance that we'll win. I don't want that to be out into the open. So sometimes we may, on occasion, go into a closed session. It's very rare, but there is that opportunity. And just again, the reasons why you don't want to violate the Open Meetings Act is because, first of all, it's not good to have somebody saying that the city of Troy did not comply with the Open Meetings Act. It's not favorable at all. It's a black mark on the city. It's a black mark on all of you. Even if it's not true, you don't want to even give rise to an opinion that that's happened. Also, there is a potential for a lawsuit to be brought, and there are some pretty stiff penalties as well. And those can be brought against the city, but also against the individual if the individual is not doing what they need to be doing and is gone beyond what we would consider just the reasonableness. If they are intentionally acting to keep the public out, then there could be potential sanctions against that individual as well. And I'm not going to talk too much about this, but the Freedom of Information Act is another Sunshine Act, and that is regarding the papers or the documents that are produced. Paul's got Mr. Evans has all of the documents that are in your packet, so you don't need to produce those. It's important that if you get communications from residents, that you give it to Mr. Evans so that he can be responsible for complying with the Freedom of Information Act requests. If you don't do that, we're likely to come to you and ask you to produce all of that. And that's not a good situation, especially because you probably have things, if you're using laptops or something, you don't want to give a court free rein to come in and look at your laptop and everything that's on it. Lawyers especially get a little nervous about that. So, and if we do have a FOIA request, we got a very limited time to comply with it. And so if you do get something from us, we hope that you will turn it around very quickly. And also it's not just writings, it's not just emails, but it's any anything that, it's photographs and papers, and it's just anything physical and tangible that we have, that you have to do your job, that is going to be subject to FOIA and may be needed to be produced if there is a request for that. And we have the burden of, if we're not producing it, we have the burden to show why we're not producing it. So it does place a burden on us. Again, it's trying to make sure and to get all this information to the public. And just like with the Open Meetings Act, if you don't comply with FOIA, again, there are serious sanctions that can be individual sanctions as well as sanctions to the public body. And then also, Alan had talked a little bit about taking recesses. I think that's a great tool. If you've ever got to the point where it's unruly and you just need to have a little bit of a break, ask to take a recess. And, the chair has got an awful lot of pressure on him, so I'm telling all of you that you can help him out sometimes. And you can ask. You can always raise a point of order. So if the chair is just having a hard time, controlling, and sometimes it's because the person is fixated on the chair. Nothing that you're doing, but sometimes a person is just fixated on the chair, and the chair is not going to be able to effectively communicate and to control the situation. So all of the rest of you have the ability to say point of order, and then the chair kind of has to act after that, has to respond to that point of order. So that is a tool. Help each other out. You got to kind of work together and trying to make sure. And that happens whether, I'm picking on you, Mr. Clark, but it could be another member as well. If there is a member that is somehow not positively interacting with the public, you can always call for a point of order. You can always call for a recess. You do have some tools. Obviously, as Alan had said, you want to always give a warning. And again, maintain the professional decorum, but try and give warnings first and foremost, and then try and take the recess, and then if that doesn't work, you do have the ability to call the police department here if it's getting particularly violent. So you do have the ability, and you know how to do that. And the vice chair knows how to do that as well, I'm guessing. So, and that's something that is provided to all of the chairs. But, certainly, the police department can get down here if it rises to that level. We're hoping it doesn't, and you've got some tools to make it so that won't happen. You can exclude them from the meeting. I would not exclude them from all future meetings, but if it's a situation where it's a particularly aggressive individual and you know that they're coming back because the matter was postponed, you may want to call the police department, alert the police department that you had this incident. Hopefully, cooler heads will prevail, and hopefully when they come back again, things will be better. But you may just want to have maybe some undercover police officers present if the situation warrants that. Any questions about that? And thankfully, mercifully, we're done. So I do thank you very much for letting us go over these things. It's been about 3 years, and if you have any questions, usually there's a question right after we are done. So please feel free to ask Mr. Motzny or myself. You can email us. Just do not use the reply to all. So, all right, thank you.
Thank you.
And just to follow up on the concern about, or not the concern, but the interest in master plan training, I'll bring that up to the planning director and the consultant, see what we can come up with.
Are we still open?
Yes.
Wait until we're closed before I
So at this point, we will move on to item number 8, which is public comment. So if a member of the public would like to address the board on any matter, please come to the podium and be recognized. Seeing that there is not any person coming forward, we are about to be adjourned unless there's something another member has concern about. Mr. Evans, you have anything? Okay. We'll see everyone in June. Thank you very much. We're adjourned.